is Grant Gunston. I'm a practicing attorney in Cape Town. Been practicing for 20-something years, and have done a fair bit of litigation in my time, but got to the point where sort of started feeling quite frustrated with some of the limitations of litigation at some point in my career, and then trained as a mediator some 11 years ago, initially commercial and family as well, and have also subsequently given quite a bit of training as well. So I'm quite a passionate believer in mediation, and yes, I think it's, it's certainly believe that mediation is not just a kind of one-size-fits-all process, but that it's actually a way of thinking which can permeate all of the work that we do. So that's what I try and build into the way that I practice law. Shall I dive straight in?
Yeah, that's excellent. Grant, on your PowerPoint slide, at the bottom, how do I explain to you? At the bottom, you see where you can make it bigger or smaller. Go more left. It's going to presentation mode. It's easier that way. No. The next icon that's there, yes.
This one?
Yes, and then it will open up a slideshow. There we go. And then you can just page up or down.
Yeah. Okay. All right. Yeah, I should have said that I'm a bit of a technophobe as well. So this looks good. Can you hear me? Should I dive straight in?
100%.
Great. Thanks for inviting me. And this is the topic that I was asked to speak on, realizing that litigation does not always give the outcomes that clients need. And I'm assuming that we're all lawyers here and probably all also have some experience and exposure to mediation. So I'm not sure to what extent I'm preaching to the converted, but if that is the case, then I just welcome conversation and hopefully we can enrich one another's perspectives on these things. So I'll just keep going on that basis. And so implied in the topic is some kind of belief that that the courts and the law is the default position, that the rule of law certainly is a lot better than the alternatives, raw kind of brute power, taking the law into one's own hands is certainly not something that is desirable for a healthy society. And so we're all very grateful for the rule of law. There's also some kind of, I think, intuitive belief that somehow the law is on the side of justice, that I've been wronged. If I've been wronged, then the law should be able to fix it. And also a sense that the law is a strong remedy and the courts are, enable strong, powerful remedies. So, I can issue a summons, the powers in my hands to initiate that and have it served on somebody without their needing to consent to that, or within the litigious process to force a response to some kind of interlocutory application or other pleading, and somehow I believe that within the legal process, within the litigious process, I can dictate the terms, I'm certainly not saying that none of that is true, but my topic is to look at that from alternative angles, and I will circle back in my last slide just to have a little bit more perspective again on the whole topic. So the big thing I think that we all know is that the courts and the law is very focused around our rights and remedies that we can achieve, and that those are fairly limited. There are only so many things that a court can do for one. Typically give you money possibly stop someone from doing something, or in very limited circumstances force somebody to do something. But usually the outcomes are financial and rights-based, but that just doesn't cover all the bases. You know, when we negotiate any other deal, we are trained and we learn in negotiation that interests are what are important and what we should focus on. And somehow it's easy to lose sight of that when we're in litigation, and all the kind of basic instincts kind of kick in. But when we focus on interests, there's a much wider range of options available to us, and this is something that the courts struggle to do. It therefore can unlock much greater creativity in the type of solutions that one can reach using mediation, and also allow for greater collaboration between the parties. Typically, the courts are set up in such a way as to pronounce winners and losers, as opposed to working out together with the parties what a solution could look like. And so using some of the alternative methodologies, it is possible to achieve what is often referred to as a 1 and 1 equals 3 type solution, something that's greater than the sum of the parts. And therein lies the creativity that, the proverbial sort of win-win solution isn't always exactly possible. That can be a little too simplistic but sometimes it is possible to achieve outcomes that are sort of greater than the sum of the parts, and actually can at least partially satisfy all of the different parties. So the classic story, which I'm sure many of us know, that sort of highlights this interests versus rights-based approach, is the orange story. 2 children fighting over an orange, parent about to intervene and cut the orange in half, and then has the wisdom to slow down and ask, what is it that you want to do with the orange? Why? Very, very key and important question. Why you want the orange? And the one wanted to eat the juicy contents, and the other one wanted to use the rind, the skin of the orange, in order to bake a cake. And so suddenly there was a much better solution than cutting the orange in half, where we both could have the parts that met their needs and enabled them to achieve that 1 and 1 equals 3 type solution. And there are many stories similar to that one. I think a key thing that is worth talking about when we talk about whether the courts always give us the best outcomes and solutions is that the court process, the legal process, is quite technical and often beyond most lay people. And with that, they give away some of their power and their agency to the lawyers and become fairly passive in the process. Obviously, they consult with their attorney and their counsel and do have moments where they can give instructions, but by and large, the process goes on at a pace that's outside of their control, and all kinds of technical factors shape both what, when, how things happen, and so the actual parties' agency and power to influence the process is drastically reduced, and that's quite a limiting factor in the court process. The sort of linked to that in some ways is the whole issue of engagement. That, as we know in management and other circles, that people support that which they co-create, and again, in the court process, there's very limited opportunity to be co-creators of the outcome. And often even a win may not be a win. A judgment can be resisted, so the party is not engaged in the process, and some outcome is imposed on them, a negative one that they don't particularly like or hadn't participated in crafting. They often find ways to resist even a judgment, obviously through appeals and endless applications, Stalingrad tactics, as it's become popular to refer to these things, or perhaps just preventing execution by hiding their assets or extracting revenge in other ways. Classic and very sad and painful example is obviously in family matters, where one parent can extract ongoing revenge for years and years and years on the other parent, just by setting up the children against that parent, by feeding the children information that is negative about that parent. And it's very difficult for a court to intervene with that. And so, yes, one parent might have got more maintenance or more assets or more time, but maybe it doesn't work out quite as sweetly as what they thought it might. So yeah, just circling back to that idea that where people are empowered to be engaged in the process, there's a much greater chance that they would then also be cooperative in the way that they implement the outcome. Yeah, another factor is time. The court process can take a lot of time. Perhaps the times can vary in the different high courts, but here in Cape Town, we typically regard about a 3-year period to get to a trial for a high court action process, which by the time you get to trial, often the matter is just thoroughly dead, and the value of the outcome can be significantly reduced. People have moved on in that time and had to get on with their lives, and so quite often just the mere lapse of time seriously reduces the benefit of any outcome that you may achieve. And of course, appeals and other applications would extend that period of time. We all know these things can go on for much longer than 3 years, even if they're taken all the way. And of course, execution, as I mentioned just now, can also extend the period of time that it takes to get an effective result. People can lead each other on wild goose chases, finding that they can't be found, that assets can't be found, and just generally having to move between one jurisdiction to another in terms of the sheriffs, etc., etc. So a huge amount of time can go by before you can get any meaningful result. Then, of course, we need to talk about costs, and there's a belief, which is not entirely incorrect, that costs go with the result, and so if you're on the right side of the law and you win, that you get your costs. But of course, it's not nearly as simple as that. Firstly, in most cases, you have to provide the cash flow as a party in terms of paying your own attorney and counsel, and that can be pretty significant, and in fact can be a reason for people to not be able to see the thing through to a conclusion. So, so costs are a huge factor. Even when you win, in most cases, you only get party and party costs, which can be significantly less than the actual costs, and the difference eats into any financial reward that you're given. And then taxation has additional costs which are not fully recoverable in most cases, and also extends the period and the runaround that one can incur in trying to recover one's costs. So even when you win, and obviously there's no guarantee that you'll win, and various other awards can be made, each party pay their own costs, etc., etc. So costs can be quite a significant deterrent for many parties in pursuing a court-based outcome. So another factor that needs to be thought about before embarking on litigation is just the extent to which that's going to take up one's time and energy as a party. It can be extremely absorbing of one's discretionary time, thought life, energy to be involved in litigation. And one can find oneself lying awake at 4 o'clock in the morning thinking about the process and using up discretionary energy, which normally would be applied to what your core business would be, which could be your business or just the joyful things that you want to do in life, time with your family or out in nature, can all be kind of eaten into by just having to be sort of playing the tapes and thinking about what's happening in the litigious process. It has quite an impact on one's sort of emotional life and can be quite draining. And that has a cost to it, not just an emotional cost, but also a financial cost if one's not able to apply oneself fully to one's normal core business in the way that you might normally have done. And so, yeah, that's a cost that doesn't necessarily always seem obvious and apparent, but I think in many cases, people perhaps looking back on a process might say they would have done a lot better to use that time and energy on the things that they do best. So that overlaps with the whole area of wellness and stress, which is very topical these days with COVID. People are paying a lot more attention to wellness, and certainly this is an area where we should be applying these thoughts as well. Certainly, there is some kind of satisfaction that many people do feel that they derive from some kind of power play, even some kind of sort of chemical release, which feels very gratifying in being able to power up on another party, which can be some kind of addiction, and which may give a short-term sort of bit of so-called pleasure, but is it really that gratifying? Is it really giving you the wellness that you think that it could or should? And that just brings us to the whole question of the sort of a short-term thinking and longer-term thinking. Yes, sometimes one can score points in the short term by bringing little sharp applications or perhaps putting somebody in an uncomfortable position under cross-examination or similar different opportunities that arise during litigation, and somehow that feels like perhaps you're extracting some kind of punishment, which gives a short-term gratification. But a year or two down the line, is that still as gratifying? Is it still as satisfying? What is the quality of the outcome? And is it useful to you a year or two down the line? I think those longer-term perspectives are often lost sight of in the intensity of some of the court moments. And certainly, I think before embarking on a court process, it's good to just stand back and weigh all the different costs, not just the financial ones, as part of one's assessment of the sort of risks, rewards, benefits, etc. And then, of course, just in its very nature, litigation being adversarial can be really damaging to relationships. When somebody's issued a summons against somebody else, you're having to respond to accusations. Often pleadings are sort of built up in the strongest way possible, perhaps knowing that they might be diluted a little bit along the way. So you sort of want to maximize on everything that you can possibly claim. But that very action and sort of shape by its very nature then produces a similar response in the way that people plead or or answer those averments, and before you know it, there's this very adversarial and damaging kind of process, which certainly doesn't tend to build people's relationships with one another. And sometimes that may not be important, or perhaps people feel that it's not important. You know, if it's some kind of once-off business transaction and you're never going to see that person again or never do business with them again, then sure, maybe that feels less important. But there are a number of instances where it certainly is important. Even where parties are divorced, they remain parents of minor children in many cases, and that's going to be a long-term relationship. And if it's a toxic one, that is extremely impactful on both the parents and the children's lives. And this is obviously something that's been recognized in the Children's Act in encouraging mediation before litigation in many aspects of children's interests. But other examples would be family businesses, so where members of a family are co-shareholders in a business, and a disagreement arises. Taking it to courts tends to have quite a serious impact on kind of Christmas and Thanksgiving and other classical business family gatherings. So again, some people would say, well, that doesn't really matter, but I think that's probably questionable for those that are able to sort of distance themselves from that situation. Similarly, neighbors who one has to sort of live alongside. Yeah, you might win, but now you have to bump into that person in the street every now and then and avoid eye contact and sort of time your driving out of your driveway so as to avoid them and have a bit of a knot in your stomach. Not really the way that you want to live in your own home. And of course, suppliers for one's business. Sometimes there's a limited range of suppliers, and a particular party might be one of the better suppliers, and now in getting into a litigious process with that supplier, the options to do business in the future become pretty restricted, and that might not be so good for your business if you've got less supplier options. So these are just some examples how relationships, in fact, are important even where there are disputes. Finding a way of somehow preserving to the best of your ability those relationships can certainly be part of a desirable outcome, which the courts don't really help with too much. Another factor is the confidentiality, and I heard some talk about that in the previous presentation. But as we all know, the litigious process is a public process. Once documents are filed in court, they're available to the public, and this may not be something that one would prefer, having to hang one's dirty washing out in public, and can be quite sort of demeaning to one's personal dignity. And certainly in business situations, that can mean disclosing information that you may seriously prefer not to disclose. It may give competitors some kind of advantage. It may give various people some kind of leverage, or just be damaging to one's reputation, and make it less attractive to clients to want to deal with you if they feel that you have been part of some kind of messy litigious process. So confidentiality is an issue in litigation, and one of the benefits of mediation is that one can agree that process would be confidential. That would be standard practice in mediation, and often that is something that all parties would both agree to and abide by. I'm referring mostly to mediation in my talk here, but perhaps arbitration also comes into the equation here, where one can, to some extent, limit the sort of availability of the information in dispute being passed into the public realm. So definitely a consideration that one should bear in mind before diving into litigation. So obviously I've, because of the topic and the nature of my talk, I've gone quite sort of enthusiastically into the advantages of mediation in particular, and some of the disadvantages, the less desirable kind of outcomes that happen in litigious processes, but that can, of course, be overstated, and I don't want to be unbalanced in that sense. So there certainly are exceptions to the points that I've been making. One of them would be where it's important to set a precedent, and you know, the law is built on precedent, as we know. The fact that many human rights issues just you know, need to be prosecuted through the courts to establish the right and protect many others who perhaps could be suffering similar issues, and so that certainly is an exception where a court process can be important and helpful. This is a slightly tongue-in-cheek one, where if sometimes, perhaps particularly as a defendant, you need to buy time. You perhaps are willing to abide the result eventually, but being able to buy time would give you the breathing room to regroup and be in perhaps a stronger financial or other position to be able to pay what's due. And so it is true that as a defendant, sometimes the court process can be beneficial to one. So I think let's not be naive about that. And no doubt there are other examples, perhaps in the Q&A, there'll be other examples that people will be able to mention. So that's my presentation. I welcome any comments or questions or other interesting additions.
Thank you very much, Grant. Much appreciated. I think it was quite an informative presentation. Just one comment I'd like to make. You know, when you speak about time delays, it's not only relevant to Cape Town. I mean, in Joburg, you'd be lucky to get to trial in 3 years. I think that's definitely an understatement. And apart from that, you know, when we talk about costs, you know, what comes to mind immediately is in family or in divorce mediation is the Brownlee case. You know, where attorneys were reprimanded by the court with regards to prolonging, you know, a matter, and you know, the costs went few hundred thousands. I stand to correction, I think it was about 750,000 rands. And thanks, Dinky, which is ridiculous. I mean, you know, that 750,000 rands that could have been put away for the kids and, you know, education or something. So yes, you know, there's many benefits of well, mediation specifically, but you know, alternative dispute resolution avenues. Colleagues, are there any questions or comments for Grant? The floor's open. Jonathan, I see your hand up, and then Madeleine.
See, Jonathan's got a question, and I've got a question.
Okay.
Yeah, thank you. Jonathan. Thanks very much, Chair. Grant, I'm interested to know about your practice in Cape Town, if you don't mind sharing a few words. How, in particular, how you balance your, I presume you do litigation as well, with ADR methods. And for example, a dilemma that I had in my previous practice was working as both a divorce mediator and a divorce litigator, and balancing the two in the adversarial context and then in the mediation context where one cannot represent either party. That was a particular dilemma I had, but yeah, I'd just be interested if you wouldn't mind just telling us a little about your practice with reference to that kind of
Sure.
thing.
Yeah, I mean, I think firstly, it's pretty clear that you can make a lot more money out of litigation. So let's be honest and say that that is something that you have to think about and get your head around. And you know, as I alluded to some extent, you know, there are different processes, different situations where litigation is entirely appropriate. I think, you know, so, but one does have to sometimes make a call that may not be in one's own interests. I think that's a matter of ethics and integrity and good conscience. And I've just found a way of weaving that into my conversations with clients, you know, just exploring, you know, the scenarios, you know, and the you know, the risks, the rewards, and the alternative strategies with them in a way that they, you know, I think many times do feel that, you know, I'm not just trying to look out for my own interests, but I'm looking after theirs, and so, you know, there's a longer term gain where people tend to respond with loyalty to that. You know, I think that one can overstate that. You know, it's not a perfect world, but that's the basis on which I kind of approach it. And yeah, I mean, it is something I struggle with sometimes, I'll be honest. You know, people in the moment that they come to see you are angry, hurt, upset, afraid, and they do want, you know, a power solution. They do want the proverbial Rottweiler, and it can seem like you're offering them weaker alternatives, you know, it's not, it doesn't always work out exactly as I would like it to, but yeah, I think just, you know, bottom line is you have to also just develop within oneself, I guess, a sense of what one's ethics are in these situations, and do the best to live by those things, and accept that sometimes you have to let something go. It doesn't work out your way, but yeah, so there can be a cost to it, but yeah, I think in the longer term, you know, I think we all want to do business with people that you know, that are loyal, that sort of appreciate, you know, the kind of approach that one adopts, and so, you know, that you know, the positive side of that is that can be a lot more sort of satisfying way to practice, I think. So I don't know if that answers your question, Jonathan.
Oh, no, thank you very much for sharing that. I appreciate it very much.
Thanks, Jonathan. Thanks, Grant. Lienke?
Now, I would also like to commend Grant for the approach followed. Now, after being in academics for such a long time, now that I experience practice a bit, I realized just how damaging our adversarial training is for families in distress. To me, the normal adversarial process, it's almost criminal to enforce that on families in distress. I just had a couple during last week, and they said, they were referred to mediation at the late stage after being in almost like the Brownlee's case. They've been in litigation for 3 years now. There's now basically nothing left for the attorneys to write fees for any longer. So now they've sent them to mediation. And it just came out in the mediation process that the husband didn't really want to fight for the children, but it was the advice that he got from his attorney. And it was because of the way that the pleadings was drafted, because all his allegations was, how do you say it? It's ontken, it's but with the contempt that he deserves. And he just said to me that it just fueled the fight. The whole legal process just fuels the fight. So I'm so appreciative of practitioners like you, Grant. That's wonderful. But the question that I want to ask you is, I know the collaborative law movement in the Cape is quite, it came off the ground, not so much in Gauteng as yet, where the lawyers are all collaborative lawyers, and you get the opponent to also go to a collaborative lawyer where you sit around the negotiation table with the clients, and the two lawyers act as the mediators. Do you experience that? Do you do that in Cape Town or not?
There are attorneys that put themselves out there as collaborative lawyers. I would say that's still very much the minority, to be honest.
Okay.
We have a nice, in the family law space, we do have a strong organization here in the Cape called FAMAC,
Yes.
which consists of both mental health professionals as well as lawyers, and that can be very enriching, and FAMAC's become quite well known and respected, I think, in the Cape, and so that does present opportunity. Certainly, if you pick up that a FAMAC colleague is on the other side of a matter, then to pick up the phone to one another and just think about and talk about the shape of the process. It doesn't necessarily mean that every process is going to be mediated, but certainly it enables you to have a different conversation with your colleague. The comment I made was just that it's a kind of thinking which can inform the way that you do practice, and something I found quite helpful in a seminar I went to once was just perhaps also an understanding that mediation isn't just a sort of a cookie cutter thing, where you somehow get people in the room and then you work through this process. Often, the very process of getting them into a room is quite a lengthy one. They just don't necessarily see the benefits initially, or they often, a huge thing is that they just simply don't understand it, and they don't know what they're getting themselves in for. That's certainly a problem with lawyers, I've found. And so one of the things, many lawyers who have now trained in mediation don't end up being mediators, and I think that's fine. The truth is there isn't enough work right now for all of the, but it's massively important that they at least understand it. I think many lawyers, have simply not been willing to sort of take their clients into mediation because they don't feel they're in control. They don't know what's going to happen there, and so at least if they have insight, that gives them another option that they could discuss with their clients. And so sometimes just realistically there's some kind of incremental process that leads up to eventually a more mediatory sort of engagement, but it's not always as sort of clear cut and simple as perhaps the textbooks or the training might suggest.
Okay, thank you.
Thanks, Yuki. Thanks, Grant. I see we've got two hands up, Africa and then Johan. Is that okay? Africa?
Thank you so much, host. And to Mr. Gunston specifically, it's quite refreshing to hear, especially from the perspective of a student who's nearing his completion of studies. And I've been looking at ADR as a potential field of study or of employment rather. And now that you've mentioned this, and I want you to be honest with me here, when we want to now step out and go into ADR as an independent standing field outside of your litigation, as you've presented very well, what are the risks? What are the chances of me stepping out and out of nowhere now saying that, okay, I want to holistically just look at the ADR aspect of mediation and conflict resolution? Can I establish an institution of my own where I then outsource, maybe then from these bigger firms that then outsource mediation cases to these upcoming little ADR firms, so to call them? That's my first question. And secondly, if then the answer is no to that, would it be more advisable for law firms, new age law firms, to then look at having an ADR leg of their help and have that as a subordinate part of the firm and not an actual firm at large? Those are just my two questions, and hopefully you can just shed some light. Thank you.
Great. Yeah. Thanks, Africa. Yeah, I mean, what I often say, and so it may sound a bit cynical, but don't give up your day job is what I say to people, because the truth up until now has been that there's not enough, even for people who are sort of fairly active mediators. It's pretty hard to have enough mediation work to be your sole source of income. So that might change. I mean, Brownlee judgment came up, and that was what, 10 years ago or something now, and we all sort of hoped and believed that was going to be a game changer, but the truth is the courts haven't massively built on that, and it's not something that fills most attorneys with a great amount of angst as they embark on litigation for their clients. Rule 41A now could be a massive game changer in that, where parties can argue the question of costs down the line if they suggested mediate, or if they wanted mediation and the other party refused it. So that may influence the volume of mediation work, but right now I would still say it's difficult to have a practice that's your sole source of income. There are some folk out there, but I would say it's very much the exception rather than the rule. So, amongst other things, be prepared to persevere, but also perhaps have some other strings to your bow. As for the larger firms, and there are one or two. I mean, Bowman's has got a ADR sort of department or whatever it's called. It's not commonplace, but that probably is something that's growing, something that firms are having to take note of and have within their suite of service offerings. Just on the forming of some kind of organization. Look, there are a number around there, so just do your homework. There are quite a few already here in the case, conflict dynamics and mediation in motion and Tukisa, FAMAC, and so on. So, just kind of do a little bit of homework and see what they're up to before sort of flying into that. But certainly there's, the space needs people with creativity and energy and who prepare to do the 10,000 hours and just become experts and meaningful contributors to the space. So, I'm not wanting to pour cold water on your thoughts there, but I'm saying just be realistic and be prepared to build incrementally. Yeah.
Thanks. Thank you, Grant. Mr. Tauber, thank you very much for your questions. Mr. Tauber is just, I'd like to tell you, he's one of our students on our Mafeking campus. You now realize, Mr. Tauber, why we've been trying to drill the Brownlee case during our lectures. You can see the colleagues doing presentations are also referring to them quite a bit. Johan, you're welcome to ask your question, Johan.
Thank you. It's actually Charlene that wants to ask. Well, thank you.
Thank you, host, and thank you for all the contributions, Grant. Well done. And Linky, I want to say, you're so spot on with that assessment. And in my talk, I will deal with exactly what you were saying. People bleed, people dry. Attorneys bleed, people dry. To the point where litigation is no further an option, and then it becomes mediation's problem. But we'll talk about that. I just wanted to say thank you, Linky, to have raised that issue, because that's a reality. Thank you, host.
Thank you very much, Charlene. Grant, I just wanted to make a general comment, and it's a personal opinion. I believe that we still have a very long way to go, with ADR and ADR methods. It's my personal opinion that attorneys in practice somewhat reluctant to actually pursue ADR, and there's various reasons. I believe that the Legal Practice Council should actually see an opportunity here to have some kind of CPD opportunity where attorneys in practice need to refresh their call it theory, whatever it is, in terms of alternative dispute resolution, ways of dealing with matters, preferably through ADR. It all goes back to what you mentioned in your presentation. I mean, trials take forever. The costs are horrendous in some cases, and the parties know what they want. I mean, or they have an idea of what they want. It is for us, as attorneys, to sit down with them and advise them correctly, and make them realize that you can still maintain a relationship, dealing with your matter through ADR. Litigation is quite devastating in some cases, but that's just some comments on my side. Again, thank you so much, Grant, for a very informative, presentation, and for the advice that you've contributed towards my students also that are present in this colloquium.
Yeah, and I'm glad to see that universities are raising awareness around these things, because I think many of us stumble into practice without the slightest knowledge of how these things work, and minimally, if people, sort of trainee lawyers are made aware of these things, at least they're equipped to perhaps find out more and develop.
No, exactly, and when I introduced ourselves this morning as Noordwes-Universiteit, also mentioned that as a final year module, this used to be an elective, and as of this year, the module has become a compulsory final year module, and we've seen the need, for it to become a compulsory module.
That's good to hear.
I see your hand is up.
Am I muted? No. I just want to let you know that I presented a webinar, a morning seminar it's the Gawe Leroux Legal Institute for Attorneys last year, but I just thought, I've got it. I delivered the presentation last year online. I was supposed to go through the country, but it was only a few online webinars. But it's a morning seminar as to why family law attorneys should incorporate mediation into their practices. So I will be willing to give it to your final students if you want that. It's just as to invite the students and why it's important for family law lawyers, if you're a family lawyer, why mediation should become part and parcel of your practice.
Thank you very much. Very kind of you, Linky. Much appreciated.